Yeah, the lawyer panel, I apologize in advance. We're going to try to not be super wonky here. My name is Mike Frisch. I'm a lawyer in Chicago in private practice. I focus exclusively on crypto and Web3. I used to work at the CFTC, so I do a lot of crypto derivative type stuff. We have a great panel here, and we all bring slightly different backgrounds and angles into the legal market with crypto. So I think I'll let each of you guys introduce yourselves.
Sure. My name is Olta Andoni. I'm General Counsel of Enclave Markets, which is a fully encrypted exchange incubated by Avalanche, Avalabs. I've been an attorney in the industry since 2017, or more years, actually. I was previous to being in-house to a law firm, and now I've been representing exchanges and other crypto platforms in the space.
Hello, everyone. My name is Andrew Gordon. I'm an attorney, also a CPA. I'm the managing attorney at Gordon Law, also the founder of Main Street Crypto PAC. At Gordon Law, our focus is crypto taxes. We've been in crypto since 2014, first paid in crypto in 2014. And we help hundreds of clients every year with taxes and other crypto issues.
Hi, everybody. I'm Robert Musiala. I'm a partner at BakerHostetler here in Chicago. BakerHostetler is a large national law firm, and my role at Baker is I am co-leader of our firm's Web3 and digital assets practice. My practice is focused on regulatory compliance, tech transactions, and investigations in the digital assets space. I also work in the larger fintech space, and my team works in just about every corner of the industry. A team of about 60 attorneys who have worked on various matters in digital assets over the years.
All right, so we're going to kind of structure today almost like a lightning round. There's so much has happened in the last 12 months. We had a panel last year, and thinking about what happened, the difference between then and now, just a year past is really kind of hard to fathom, and that's true on every level, whether it's the legislative front with federal agencies in the states. It's just been, there's so much to cover, so we're going to try to be quick. We're going to start with sort of clarity and genius, and I'll direct the first question to Andrew. Andrew, you're deeply involved in what's going on in Washington. He mentioned he has a PAC, a political action committee, that's very involved in trying to shape the federal legislation. So if you could you talk about what's been happening over the last month, and where you give a kind of an overview of genius and clarity?
Sure, Mike, and you're absolutely right. The last year has been basically night and day from the last 10 years. And I'd like to begin by saying that it's been an absolute honor to work with leaders, visionaries who believe that the U.S. economy should be expanded and that crypto is the future in the U.S. and that future needs to be in the U.S. rather than another country. And that's been a big change that's happened over the last years. Leaders like Senator Lummis, the crypto queen, Senator Blackburn, Senator Haggerty, and Moreno, people who are leading the charge and believe that these changes should occur. And that's, all of this has been the brainchild of Main Street Crypto PAC, which is an initiative to help make sure that in DC, the voices of everyday investors, not just the big Wall Street companies, but the small companies that are trying to begin, the investors who are trying to get access to tokens, that these types of people have their voices heard and that legislation is implemented to benefit them and create new wealth. Genius and Clarity have been clear examples, no pun intended, of these types of efforts. Genius, very fortunately, was passed into law just last week, signed by President Trump at the end of the week after kind of a lightning round in the House. Genius, for those of you that don't know, creates regulations for stablecoins. Stablecoins are perhaps one of the best use cases for crypto. They allow money to be sent globally 24/7 with low fees, but at the same time there have been a lot of issues with stablecoins. For instance, you don't necessarily know if they're backed by dollars. There hasn't been regulation that allows issuers to launch stablecoins in the US and know that they're not going to be subject to enforcement. So although there's these great benefits for stablecoins, there hasn't been the rules of play of how to use them properly in the U.S. And Genius filled that gap. It created requirements for reserves. It made sure that issuers would be subject of audits and that they would actually be backed one-to-one by U.S. dollars or U.S. treasuries, creating greater demand for U.S. dollars, treasuries, overall just a great thing for the U.S. economy and for crypto. The Clarity Act is an attempt to answer the question that's plagued the crypto industry really since the beginning, which is what is a security and is crypto a security? Because this question hasn't been answered, the SEC has had in many ways, a reign of terror through enforcement, where crypto projects aren't sure whether or not they are a security. The Clarity Act tries to create clarity around this, identifies what types of tokens would be under the CFTC versus the SEC, and a framework for decentralized tokens to be outside of these security parameters. The current status of the Clarity Act is that it has passed the House. It's now going to the Senate. At the Senate, there's a new draft that's open for comment until August 5th. I encourage all of you to voice your comments, read this legislation, because it does have a considerable impact on crypto tokens in the future. So these are pretty massive steps forward at this time.
Thanks a lot. Let's go a little bit out of order and talk about clarity first, I guess. So there's been a lot of talk about the Genius Act today. What do you think? Let's give people some alpha here, Olta. So what do you think it'll pass, and how is the Senate version different from the House version? And if it does pass, what effect is that going to have on the market?
Actually, I mean, first of all, let's say that Clarity Act definitely is a good progress when it comes, I mean, compared to any previous bills that we have seen for our industry. However, if you asked me this question last week versus this week, my answer would have been a little bit more optimistic, because what's happening right now, we do have a new draft from the Senate Banking Committee. And that new draft was just published on July 22nd. And the more I read that draft, the more I understand that there are some substantial differences between the Clarity Act and the Senate Act. And to complicate things even further is that we do expect a new draft from the Senate Ag Committee, and that draft definitely is going to focus a lot more on CFTC jurisdiction, per my understanding, and it's going to focus a lot probably on 70% language of the Clarity Act. So what are the main differences that I am concerned as an attorney, especially for the builders and the protocols in the industry? First, under the Clarity Act, those decentralized or DeFi exemptions for DeFi protocols that were under Clarity Act, they are being omitted under the Senate Banking Committee draft. And I hope that, I mean, protocols and people and especially GCs on behalf of protocol are going to submit these comments, because we do need those exemptions and those protections for security laws for DeFi protocols. Because under Clarity Act, we did see those exemptions, especially for validation nodes and other exemptions, very beneficial. The other thing that it is quite concerning is that now they're focusing a lot more on digital commodity definition versus ancillary asset definition. So under the Senate draft, we do not see that linkage to the network. Or a blockchain network, but I think it's Section 102, if I'm not mistaken, that kind of expands the Reg D application as well, which I think is going to be beneficial for many protocols. The other thing is the domiciliary provision, because under the previous Clarity Act, all the protocols, in order for that act to be applicable, they need to be domiciled in United States. Something that I like under the new Senate Banking Committee draft is that they do not have included that domiciliary inclusion, which means that, you know, protocols can still launch from other jurisdictions. I do think that, or my concern again, is that when we have both these drafts from the Senate Banking Committee and from the Senate Ag Committee, it will be how well they're going to work together. And it seems that the draft that we expect from the Senate Ag Committee probably is not going to be out until beginning of September, hopefully. And if we go by the timelines that White House is pushing for the Clarity Act to pass through, which I think is October, unfortunately, I'm not that optimistic that we're going to have sort of that correlation between these two drafts in order for, I still hope that we're going to see Clarity Act move from, but I do think that these are very, very substantial differences. And then even the pre-exemption for token raises, I think is $50K for the first, for 12 months under the Clarity
50
versus
million?
50 million, yeah, versus 70 versus 75. No, it's 50K versus 75K under the new Senate draft. So yes, there are some substantial differences. So we'll see where that goes.
Okay. Well, thanks, Olta. We can all be hopeful. Robert, you've studied the Genius Act. What are some of the issues that you see that are yet to be resolved, and how do you think that the world's going to look a year from now or a couple years from now? Actually, maybe I think it's 3 years from now after Genius Act goes into effect. How is it going to affect the financial system?
Well, so I think the Genius Act, very simply put, brings stablecoins into the mainstream financial system, period. And that's a huge development. And it does this by regulating stablecoin issuers like the traditional financial system is regulated. So for example, stablecoin issuers will be required to have reserves that are limited to specific liquid cash and cash equivalent type reserves, and that'll be a limited list. They will be required to undergo monthly audits, and those or monthly examinations by a U.S. public accounting firm, and the results of those examinations will have to be published on a monthly basis by the issuer. Stablecoin issuers that have market caps of 50 billion or more will have to undergo annual audits, just like any public company, whether or not the company is public. From a Bank Secrecy Act and anti-money laundering perspective, stablecoin issuers will be treated just like any other financial institution. So they're going to have AML programs just like any bank has an AML program. From a consumer protection standpoint, in the event of an insolvency or bankruptcy, there's a clear priority where first priority goes to the retail holder of the stablecoin. Second priority goes to the custodian of the reserves backing the stablecoin. And the last priority goes to the actual stablecoin issuer. And so these and other requirements in the Act are designed to provide consumer confidence in stablecoins that are regulated under the Act in the U.S. And so the result of this is going to be that stablecoins will become a payment option just like any other payment option, whether that's for a financial institution to financial institution transaction, a business to business transaction, a peer-to-peer, individual to individual transaction, or I think one very good use case will be individual to e-commerce merchant transactions, and I think we'll see that as a growing field. But in any of those scenarios where the transactors are asking themselves, what type of mechanism should I use to conduct this, a stablecoin transaction will be treated just like any other. And in a lot of cases, it's going to make the most sense to use a stablecoin for that transaction. So that's how it brings generally stablecoins into the mainstream. I will also note that it also brings DeFi into the mainstream in a lot of ways because, as some of the other panels have noted, stablecoins and especially US dollar-backed stablecoins underpin a lot of the decentralized finance ecosystem, and DeFi relies on those stablecoins for liquidity. And so by creating confidence in US dollar-backed stablecoins regulated under Genius, that brings additionally an air of legitimacy to the growing DeFi industry.
You know, everybody wants yield on their stablecoins. Do you think that, I know the Genius Act prohibits yield-bearing stablecoins, but do you expect to see regular people like staking into Aave and Uniswap for yield, or do you think issuers are going to find ways to get around the yield prohibition? All my clients want to know, how do we issue a stablecoin and still give people yield in the U.S.?
Well, as you noted, Mike, under the Act, you can't do it. So, stablecoins under the Act cannot be interest-bearing for the retail holder. I will note, one interesting thing that I noticed in the law is it requires a study for so-called collateralized stablecoins, and these are products where it's a stablecoin that is not backed by a US dollar, but instead is backed by some sort of basket of other cryptocurrencies or other value. And I found it interesting to note that the Act requires a study to be done on the viability of those products. So that could be a hint as to where some of this might be going. I'll also note, and Mike, you hinted at this, but we're at the very beginning stages of the Act. It hasn't been implemented yet. We have just started the process of implementation, and there will be lots of regulations issued interpreting the Act in the next 12 to 18 months, and that's where some of the answers to these questions may appear, and there will also be a public comment period along the way, and so industry will have an opportunity to comment on what they think some of the details should look like.
Yeah, I mean, like, nowadays, if you use a credit card, some cards will give you, 2% cash back. It's hard to see, if you're, a cash back program, the difference between that and earning interest, like, it looks similar, so it's hard to know where some of these details are going to shake out. Okay, so let's pivot away from those are the two big sort of legislative updates. What has changed, Robert, I'll start with you. What has changed in the last year with respect to the SEC and the approach to crypto? Big question.
So there has been a whirlwind of change. So I'll just provide an update on the biggest changes each month since the beginning of the year, and that's going to be a lot. So in January of this year, we had the crypto task force that the SEC was founded. And also in January, the SEC published Staff Accounting Bulletin 122. SAB 122 changed the rules for third-party accounting for third parties that are holding crypto assets on behalf of third parties. The old rule said that if you're custodying crypto on behalf of a third-party customer, you have to record that as a liability on your balance sheet. Under the new SAB 122, the rule gives the company or person discretion as to whether or not to report a liability as a loss contingency and defers to standard accounting principles to make that judgment. So what's the effect of that? It allows an environment where crypto companies can provide much more favorable balance sheets. That, I believe, leads to opportunities for things like initial public offerings, and also in the private markets allows for capital to be raised more easily by showing a more favorable balance sheet. So that was January. In February, the SEC published its statement on meme coins, which basically said that meme coins that meet certain criteria and are limited to use for entertainment, social purposes, and similar purposes will not be deemed to be securities. So that gave a lot of confidence to businesses working with meme coins. Then in March, a statement on proof of work mining activities, which is fundamental to the blockchain space, with Bitcoin being a proof of work mining network. And that statement essentially said that persons engaged in proof of work mining are not engaged in the offer and sale of securities. That was March. In April, a statement on stablecoins, saying that stablecoins that meet certain criteria would not be considered securities. May, statement on protocol staking activities, giving the market clarity that node providers on proof of stake markets and other parties engaged in staking ancillary activities would not be deemed to be involved in the offer and sale of securities, so giving a lot more confidence to the proof of stake industry. That was May. In June, two speeches of note, one by Commissioner Peirce, where she indicated that the developers of software code protocols should generally not be regulated, and rather it should be the users of those protocols that should be regulated based on how they use the protocols. So creating an important distinction between developers of software protocols and the users. And then Commissioner Atkins, Chair Atkins, issued a statement where he indicated that some of this guidance should eventually be codified in a regulation. And so that may be a development we see this year. And also indicated that he's interested in considering what he called an innovation exemption that could provide some exemptive relief while all of this stuff is worked out. And then finally, this month in July, we had the SEC publish its guidance on exchange-traded products, which provided guidance for applicants for crypto exchange-traded products and gave some very specific details around what's expected in those applications, and hopefully that will streamline the processing of those applications at the SEC.
It's amazing. Olta and Andrew, what about the enforcement picture for the SEC?
Definitely we have seen a lot more change on the enforcement picture since beginning of this year. But even in 2024, I think we did see a big drop on enforcement actions, almost like 30%. But as far as fine, we still see quite big fines for the enforcement action that they undertook. I do think that, definitely this is a good sort of vibe in the industry with enforcement actions against the major crypto firms like Coinbase and Uniswap and DRW, et cetera, that, we just don't have time to mention everything, but I think that that is definitely very positive for the industry, but you need to pay attention to the latest DOJ action, for example, against SafeMoon. So I don't think it's all, butterflies right now.
We've seen, but the big headline is a lot of these sort of more aggressive interpretations of the securities laws have been, dismissed out of court.
Absolutely. But I think now, once we have this, hopefully the Clarity Act as well, we're going to see from the regulators, both CFTC and the SEC, to concentrate more on the statutory law versus their own interpretations.
Yeah. Andrew, you're a tax lawyer, and it's my impression is that the IRS and then the CFTC, which we'll get to next, have been relatively or comparatively slow to issue guidance. Do you agree with that? And what's changed with respect to the IRS?
Yeah, absolutely. I think everyone here could agree that crypto taxes are broken. I'm not going to ask people to raise their hands if they've reported crypto on their taxes, but I would assume there's a large percentage who want to report, don't know how, and fear that if they try to, that the IRS is going to audit them, penalize them, or throw them in jail. And unfortunately, that's been the reality that we've lived in for the last several years, where IRS audits, criminal investigations, has been the way that regulations have been released. Much like the SEC, where it's been regulation by enforcement, we've seen the same with the IRS, except taxes impact all of us. Every individual, every business in the U.S. needs to pay taxes. And so crypto is such a large opportunity for tax collection, yet at the same time, we haven't had the month-by-month guidance being released that we've seen with the new administration at the SEC, which is fantastic, by the way. But with the IRS, crypto has maybe a handful of guides or regulations, including an FAQ on the IRS's website. Crypto being something that touches so many Americans. On the other hand, something like opportunity zones, only 10,000 people took advantage of opportunity zones, yet there are hundreds of pages of guidance. There have been several congressional hearings, on and on we go. Taxes is the next battle for crypto regulation. It's one that I'm trying to fight towards at Main Street Crypto PAC. We need to make sure that everyday investors can report crypto on their taxes and that business don't have to fear including crypto because of a lack of uncertainty about taxes or having to hire someone like our firm, which happy to be hired by you all, to do your taxes. But you shouldn't have to do that in order to report crypto in the U.S.
But Andrew, what are the big areas of uncertainty still?
The list goes on. For example, just this week we had a client who donated Bitcoin to a registered charity, 501c3. The IRS audited him, assessed a penalty, $500,000 of Bitcoin donated, said you didn't get a qualified appraisal. We don't know what this Bitcoin is worth. Old regulations that say that you need qualified appraisals for things like works of art or collectibles. Bitcoin, perhaps one of the most traded assets that second by second the value. Lending, staking rewards, swaps, airdrops, all of the things that everyone here deals with on a daily basis, there's been essentially no guidance from the IRS. Contrast that to something, again, like opportunity zones, pages and pages of guidance, very few people that are actually impacted by it.
And, well, thanks for that. And we only have a few more minutes left, but Olta, I used to work at the CFTC. Olta, you're a derivatives lawyer. It's been my impression similarly that the CFTC hasn't really done much. Do you agree with that?
I fully agree with that, but also I think like that is because I always see CFTC more focused on principle-based sort of approach, and I think that this is sort of a deliberate action in my opinion, because I think they're waiting for Congress to act, and unlike the SEC that usually rely on very old laws, 1930 laws or so, I think that CFTC is definitely waiting for that congressional approach. But I think that, for example, we have seen the Binance case was one of the biggest cases that we saw some sort of where the CFTC is heading toward the interpretation or what sort of guidance they were giving out for the builders and protocols. But at the same time, we haven't seen much, especially for perp derivatives. We haven't seen how these offshore perp derivatives can be brought back in the United States, which hopefully, I mean, we're going to see some guidance, even though I'm not very optimistic there coming from the CFTC. So probably after the Clarity Act, or hopefully, once Clarity Act passes, I do think that we're going to see CFTC more involved as far as interpretation based.
Well, thanks for that. We're out of time. If anyone needs free legal advice, please feel free to come back up to any of us afterward, and we'll be happy to hook you up.
Thank you.